This program is brought to you by Emory University.
So good afternoon, and once again, my name is Melissa Carter, and I'm the director of the Barton Child Law and Policy Center here at Emory Law School. And it's my privilege both to welcome you to today's Child Welfare Legal Academy and to introduce today's speakers and our topic. So today's Legal Academy will focus on closed adoption and sealed adoption records, open adoptions, and post-adoption contact agreements, as well as whether there should be a response from the General Assembly. As I go on to read their formal introductions, I think what I would like to convey to you is that these are the two people who've been leading this public conversation in Georgia for as long as I've known, as long as I've been around. As usual, we try to bring to you the best experts we can on particular topics, and we've certainly found them today. So I welcome you and thank you for your interest in this topic. You do have all of the presentation materials there before you, and the speaker bios are with those materials, so I won't read them to you word for word, but I do want to do the honor of giving a brief introduction to our today's visiting scholars. With us today is Representative Mary Margaret Oliver, who is a native Georgian from DeKalb County. As you all know, probably know, Representative Oliver has served in the House of Representatives and in the state Senate. She also, for a number of years, she also ran for lieutenant governor. So what we want to say about that is she's a veteran for us at the Capitol as a champion for children and children's issues. She has had the distinction of serving as both the chair of the House Judiciary and Senate Judiciary Committees throughout her terms in those chambers. And that is the distinction of being the first person to serve as the chair of both of those committees and as the first woman to ever serve as chair of either committee. So her leadership is well noted in those areas. She currently sits on the House Appropriations, Judiciary, Government Affairs, and Science and Technology committees. She has been appointed by the Georgia Supreme Court to the Committee on Justice for Children and by our Governor Nathan Deal to the Special Counsel on Criminal Justice Reform, which many of you may know is taking a keen interest now in issues of juvenile justice system reform. And so we're really so grateful to Representative Oliver to steer those conversations. Representative Oliver has a significant record of legislative accomplishments, including authoring and passing legislation for the protection of children and consumers, including Georgia's anti-stalking law, and a number of legislation geared at protecting neighborhood activists from intimidation, as well as general business and legally related bills. I've had the distinct personal pleasure of working with Representative Oliver on a number of child welfare-related legislation proposals here in the state, and so that list could go on and on and on, but you've seen her fingerprints all over our laws in our state. Representative Oliver earned a BA from Vanderbilt University and her law degree here from Emory University. From 2001 to 2009, we had the privilege of having her as a visiting professor at our center. In 2011, in honor of the 175th anniversary of Emory, Representative Oliver was honored as one of 30 women out of about 175 Emory history makers. Those individuals who have shown courageous and ethical leadership on behalf of the greater community and a legacy of imparting knowledge to others and making significant contributions to the life at Emory. And she has a medal. And even in that abbreviated bio, clearly she's earned the medal. And so, yes, please wear it. And on top of all of those things, she also practices law, by the way, in Decatur. I've also had the personal privilege of working with our other speaker, Jim Outman, for a number of years. He taught me all that I know about practice, and particularly practice in adoption, so I can't think of a better expert, and both of our speakers are dear to my heart. So Jim Outman is a private practitioner. He received his law degree in 1971 from Georgetown. He and his wife have been together for 46 years, and an important note of personal experience, he's an adoptive parent. So he speaks both from his legal expertise as well as his personal life experience. He's been the principal author of Georgia's adoption statutes for the last 37 years. We all refer to him as the architect of Georgia's adoption statute. So again, the pairing between them is a powerful one. And he's written and lectured extensively on adoption law and practice here in Georgia. He presents at the ICLE Adoption Law and Practice Seminars since 1993. He's chaired them since 1995. And he too has earned a distinguished honor. For Jim, it was in 2003 as an angel in adoption by the Congressional Coalition on Adoption Institute. So lots more could be said, but that would rob us of the ability to turn this over to them and actually hear from their expertise and their perspective, which I will do now. So please join me in welcoming both Representative Oliver and Jim Outman, who will present to you on open adoption issues. Thank you.
Thank you, Melissa. It's indeed my pleasure to be here and to participate in this presentation. As we said it at the outset, we're going to take questions at the end. I guess I would make the one caveat: if you can't listen to anything else I'm saying or Mary Margaret's saying because your mind's blocked by this question, do something. But otherwise, the flow will go, and you have every slide that we're going to present, and there's a place there to put notes. So if something we say that should complement the slide is noteworthy, you can write it down. If I can do this, there's our topics. I'm going to start off talking about closed adoptions and sealed records, a little bit about open adoptions, a concept, and then we're going to take a break, and then we're going to go into the open adoptions and post-adoption contacts agreements. Here's a quote from Alex Haley. Some of you will know when this book came out. Others of us just date ourselves by that. But the key is that he was not speaking only of children who are raised in their family of origin. Research, experience, and instinct all affirm that his eloquent observation that belongs to adopted people and adopted individuals as well. They just don't have the ability to say, "Hey, Dad, did your father come from Spain or Northern Africa or Southern Africa or South America or what?" Because he could say, "Well, I can tell you where he came from, but it doesn't make any difference where your birth father came from." Closed adoption is defined as, for purposes of our discussion, as a birth parent and adoptive parents do not know each other. As you said in my introduction, I have a 39-year-old son who we adopted through DeKalb County DFACS, and I know nothing about his birth mother and therefore can tell him nothing. Well, we know that she was 16 at the time, and he was born out of wedlock. She was 16 and had the support of her family. I've just told you everything I've been able to tell him. And likewise, she doesn't know where he is. She doesn't know that I'm an old bearded lawyer. By the way, I'm getting ready for 2 months. I'm going to speak about adoption records, and by that I'm talking about the court pleadings, adoption agency files, and vital records, because they come into play, as I'll explain. And on vital records, we have the original birth certificate, or I'll shorthand OBC, and we have an amended birth certificate. A Georgia-born individual who was adopted prior to July 1, 1941 may have access to his court pleadings and his adoption agency files just upon request. They're not sealed. But he's still not entitled to his original birth certificate, him, her. For adoption pleadings, again, finalized after that date. So if it was filed before that date but not finalized until after July 1st, it's sealed. And the sealing activity comes from the adoption code. And they're only available as provided in the adoption code. Court pleadings are located within the superior courts of the various 159 counties. By the way, did you know that Georgia's number of counties is the largest in any state in the country?
Except Texas.
Texas? Okay. I thought read one maybe that was east of the Mississippi. But anyway, it's still a big number. And Texas probably doesn't beat it by much, does it, Mary Margaret? No. but we could fit a couple of us in there. So there are 159 possible locations, and if you know a person was adopted but don't know what county, it's going to be hard to go to the county to look for their adoption records. Agency adoption files are retained by the agency that facilitated the adoption and by the Georgia Reunion Registry. And I'll speak of that more, but if you look in the adoption code, it provides that at 19814i, that the clerk of the Superior Court is required to send a copy of every pleading filed in the Superior Court in the adoption action to the Department of now Human Services. for retention. That became the reunion registry. That was the body of knowledge that was there. And it was archived, and you could only get to it if you knew where to go and whatever. And I'll talk about that a little later. But the point was we built the reunion registry in 1990 on top of that. But that's why if you didn't know what county to go to, if you go to the state, the county information should be there. Should is the operative word in that sentence, because if the clerk didn't do what the clerk was supposed to do, you weren't going to find it. Families First, which has been in 1990, I think, celebrated its 100th anniversary, is the only organization that's a licensed child placing agency that was in operation prior to 41 that's still here. So if you're dealing with an earlier record that I said the adoptee was entitled to upon request, the request is going to be made of Families First, because that's where it is. That's where the agency files will be. The court pleadings will also be at the state and may well be in Families First files, because they may not have every pleading. If there was a motion or an interlocutory rule nisi or something, they might not have that, but they'll usually have the petition and the order. But all other pre-41 agencies that have gone out of business should have surrendered their files, their records, to the state. So again, as the keeper of the state archives, not at the state archives, but at Vital Records, at Human Resources, Human Services now, that's where they are. In 1990, we recodified the entire code chapter, chapter 19-8, and at the time added a new section, which is 19823F, as the reunion registry. So when I speak of the reunion registry, that's where it came into being in 1990. And a search may be initiated by an adult adoptee, have to be over 21 in that provision, the sibling of an adult adoptee, and the adult adoptee can also seek their siblings. And it can be, we've since added, when it was first passed in 1990, it did not allow a birth parent to search. The birth parent had to sit by and hope that the child they placed for adoption would want to find them. They couldn't go out and try and find the adult adoptee, but now they can. The registry uses an intermediary. So when you contact the registry, if my son were to contact the registry, I can't, he can, and ask them that he'd like to see if his birth mother would want to meet him, the intermediary through the reunion registry makes that contact. There are forms that a birth parent and an adult adoptee or an adoptee can file with the reunion registry to consent to those contacts. So a lot of times in an adoption, you ask the birth mother, do you want to go ahead and sign this consent to contact, so that in 21 years, if your son or daughter asks to contact, they'll pull it up and say, oh, if she's already registered that she's okay, let me call her and put you together. You can change that. You can also file a decline to contact, and you can change it at any time. So if they get a match, their job under the reunion registry is to effect a reunion. So they say, Jim, you can call Beverly. Beverly, you can call Jim. Here's how we can put you together. What kind of meeting do you want to have? Do you need a referee? Do you need you both been searching? Where are you in your comfort level? In the last 22 years, the reunion rate, I call it reunion rate, is above 90%. The rate of, once they've been located, agreeing to contact is above 90. Of the total, so I count, that's a subset. They have a number that they have found, but they're deceased, and we amended, subsequent to its original creation, we came back in and amended that if that's the case, you communicate that information to the requester, the name of the decedent, where they're buried, or whatever you know about the closure on that search. And then there's a very small segment that they can't find, and then there's almost a smaller segment, I think it was 4.3% of the people found declined. And this is why I find we'll talk later about the General Assembly, and all my comments about the General Assembly exclude this noble lady sitting over here, because she was a co-sponsor of the bill that I'm going to mention. But we had legislation pending about trying to get the OBC opened. And, yeah, original birth certificate. Again, I prepped that I would probably lapse into that. I think it's very compelling that only 4% of the people asked declined. We are in a majority rule country, democracy, and that ought to be compelling, but no, we wouldn't.
Jim, I'm going to interrupt
you. Yeah, ma'am.
When I carried the original birth certificate bill to the floor of the House, it was defeated on the floor.
After it had passed in the Senate.
Not very attractive.
Not
very interesting, not very attractive debate. And I will tell you that the most compelling voices to me were colleagues who came up to me, and there was more than one, lawyers, who said, Mary Margaret, what you're telling me is that I promised that birth mother this would be confidential, and you're telling me that my promise I cannot keep. And that was in the mindset of the practitioners at that time. And I had made those promises.
And I would say that there's nothing in the law, we'll talk about opening a birth record, and you'll see that they've always been openable. So if they don't have to come to you to ask can they open, but they can come to her, how can you promise that she'll keep it closed? So the people who made those promises did so mistakenly, but then obviously that's motivating them to say, no, keep it locked down. But it's not what we're going to eventually get,
and
I hope.
The other people who came to me on the floor of the House were basically afraid of contact. That was the
Yeah, and there again, we'll talk about it, the fears of those contacts, because we've got a number of states have opened them, they didn't materialize. The adult adoptees aren't a bunch of stalkers that are looking around to terrorize people. So, in the reunion registry, if you have an unsuccessful search, in other words, it comes back and says we couldn't find a person, or we found them and they said no, then you can go to the Fulton County Superior Court and ask for judicial permission to get the records. The burden of proof is that the failure to release the information would have an adverse impact upon the physical, mental, or emotional health of the petitioner. Well, think about it. Majority of you in the room, women, but it applies to men too. When you go to a doctor, they ask you something about your mother's history. Typically GYN-wise, that's one of the first questions. Beats the heck out of me. Can't answer it. Did that impact your health? It may have. I submit that a person without that medical history usually has to go through more testing. They have to eliminate things by doing a diagnostic test that you could have answered. I think that's an adverse effect on their health, but again, that's part of an argument. The Georgia Reunion Registry, here's the contact information. The program manager, the contact specialist, administrator, their website has information on how you initiate things, the forms and whatever. You first have to get a request for your non-identifying information. They go through the file and redact names and give you what they have. Some people, that's just enough. But the person who wants to say, I want to see the person. Now, vital records, remember I said there were court pleadings, agency files, and vital records. Vital records is now under the Georgia Department of Public Health. It maintains birth records in the state since 1919. In 1941, the U.S. Children's Bureau approved the practice, which continues today, of creating birth certificates for adoptees on the basis of the information to list the adoptive parents and change the name of the child and everything else in an amended birth certificate. So if you meet someone like my son, his birth certificate looks just like everybody else's birth certificate. It doesn't say adopted on it, doesn't say amended on it. It just says that I'm his dad and Mary Jane's his mom, and his name is, his date of birth stays the same. It's supposed to be the county can be moved around. If he was born in Savannah and Glenn County, and Mary Jane and I were in DeKalb County, we could move his birth county to DeKalb. Used to be, if you were born out of the state, they could issue you a Georgia birth certificate saying you were born in the state. They've stopped doing that, but that created double counting in my understanding. But the U.S. Children's Bureau, so a national body, started saying this is the preferred thing in 41. This is the code section that says that you get it's called a certificate of adoption that is filled out when you complete an adoption. It lists the data about the original birth certificate, then it lists the names and what you want on the amended birth certificate. It's signed and sealed by the clerk of the Superior Court to confirm that there is an adoption that does that, and it goes to Vital Records. That generates the amended birth certificate. The original birth certificate gets a stamp on it that says canceled by adoption. A nice thing to show you that you're canceled. But, and then it's sealed. And it says in that last section, and it shall be certified, okay, excuse me, that's not the one I thought it was. This one says it prepares the amended certificate, and the last line says, and seals the OBC. So this is where it's getting sealed. Now we look and say, how can we get to it? And it says, shall be subject to exception, shall not be subject to inspection except upon order of a court of competent jurisdiction or is provided by statute. And I can't find any statute that gives permission for that. Earlier in the history it said by regulation, and I thought, hot diggity, all I got to do is get the Department of Public Health, which usually says, we got no objection, you want to see the file, just go get a court order. I could get them to change the regulation, but I'd have to go back about 30 years to do that, so I'm not going there. I mean, in fact, it's more than 30 years. So we got to get, so then the question is, what's a court of competent jurisdiction? I don't know whether it's a magistrate court. It's interesting too, in the history of that section, it used to provide superior court. So I think I would argue legislatively history. I guess I could argue both sides. Since they took superior out, it must have broadened it. But if we said, well, the only one they did specify was superior, so I've always taken my cases to superior court. Here's the rub. My son has to go to court to get his original birth certificate. Every one of you in the room who's not adopted just goes and asks for it. Both of us have to pay the same fee. But why does he have to go hire a lawyer and go talk to a judge, and there are 220 or thereabouts superior court judges in the state, so that's 220 different standards of whether they think you ought to have it. Son, go on home. You don't need that.
You ever had a judge deny your request to unseal adoption record?
Adoption records, yes, not an original birth certificate. So, and I want to get into that because I'll talk about, I see in education, some of them need to be here. The code does not specify a burden of proof. This needs an order. Lengthy oral argument, the state didn't used to oppose these. In the last 2 years, they've started a change in personnel over there, and somebody, I guess, takes it as their duty to get to court, but they've consistently opposed them. Even when my client knew their birth mother's name, knew she was deceased, and I said to the attorney, what information do you believe is on this document that she doesn't already know? We still oppose this. The judge in that case agreed that the request had to be reasonable, but I would submit that anybody who's an adult adoptee asking for their record, I can't get Melissa's record. She can't get my son's. You have to have a familiar relationship to the individual you're searching for. But anyway, here's the regulation, the rules and regulations. It also parrots the last line there, order a court of competent jurisdiction. So that didn't provide us a route. I'm of the opinion that it's the first record of the adoptee's birth. It belongs to him or her. She or he is entitled to it. Entitled to the order, because they're entitled to the document itself, but you have to go through this procedure. Our last line of the topic is there anything the General Assembly needs to do? And I say yes, and as I say, with this being a new session, it will be reintroduced as a new bill this year. When Mary Margaret stood in the well and got shot down in a very painful, because we'd passed the Senate 50 to zip, and we went through House Duty, clean bill, and she got tacked up against the wall down there, and I remember her email to me. That was the most painful, one of my most painful stands before my house body. We tried in 2000, I think it was 1, 2, 3, or 4, 2 or 3 of those years, and we're getting nowhere. So we licked our wounds, and we came back this last session and got out of house duty twice with due pass and couldn't get to the floor. It's going back in January, so stay tuned. But we believe it's a matter of civil rights, and we know far more now as to why things were changed. And I'll jump ahead to one of my slides, but the enemy we got is that in the hearing they'd say, well, wasn't the mother promised anonymity? Back to the questions that Mary Margaret got. Wasn't she promised that no, there's no evidence that they were ever promised anything. In fact, if you study that period, these records were closed, as they say, in Georgia in 41. Alabama didn't close them until 1990, and they opened them in 2000. So it was a movement that was going that people tended to think, well, we need to close it. But it was never closed at the request of or at the behest of the birth parent. And where I was going, Dan Rather did a documentary here recently, within the last year or so, on birth mothers during the 50s and 60s in this country. It made me cry when I watched it. I'm not embarrassed to tell you, I cried, because the pain those women went through. We were taking care of these fallen souls that had dared to get pregnant out of wedlock. They were made, I mean, they talked about in labor in the hall on a gurney with nobody caring for them. I mean, it just, I'm sorry, that's off the topic, but it bothered me but we learned that since 2003, there have been 2 studies, and they're mentioned at the end of my materials, by the Evan B. Donaldson Adoption Institute, one in 2007, and then they updated it in 2010, which document the history of these closures and the whys and the why nots and where we've come. I remember 1990, I went to Washington, D.C. at the request of the state to attend a Casey Foundation seminar on open adoption, or no, post-adoption support. And I said, there is such a thing? As an adoptive parent who you're done, you know. Good, you have the child now? You know, can I get any help? No, now you can. There's a foster parents and adoption support center and everything else, great resources. But it didn't used to be that way. Well, anyway, I went to this seminar, and there were child welfare professionals who stood up and said, we closed adoptions and we told birth mothers, go on and get on with your life, forget about this, with the purest of emotions and purest of interest, but boy, were we wrong. I tell you, as a man, I can't believe that a woman could give birth to a child and forget it. So how in the world could they tell them that? But that's what they did. That was the accepted philosophy, and we've come through that to where that isn't the philosophy now. Okay, so back to why were agency files sealed? The principal reason for creating an amended birth certificate was so that my son didn't have to explain a different name on his birth certificate from who his parents were. Because if you didn't create an amended birth certificate, you were stuck with the parents that you had at birth. And then you had to explain that. And you could be, I call it part of the modern bullying. Today we would call it bullying. It's another reason to pick on that kid. But the biggest reason was the protecting the adoptive family, because when I started practice of law and when Mary Margaret started practice of law, the statute of Georgia said a child born out of wedlock is a bastard. That was softened to illegitimate, and now it reads out of wedlock. But we've become a little more socially acceptable in our parlance, but that bastard kid was the one that would be picked on if they could know that. That was the reason we sealed these records. Didn't have a blasted thing to do with moms. Mom didn't count. sorry to say, but it was focused on the adoptive family too, to protect that adoptive family from being the family that raised the bastard. Where's the bastard on the block? Oh, it's the Jones family down there. They're the ones. And you're shaking your heads thinking, can that be? Yes, it was and it is or could have been, and thank goodness we're beyond that. But that was the reason, and these studies documented that. So the poo-poo we heard before about, well, mothers aren't here to tell us, but we believe they were protected, and we're arguing against the empty chair, and the empty chair won. And that's a little defeating, to think that it reminds me of a friend of mine who called me, and he said, Jim, I want you to read a Court of Appeals decision. He said, I took the appeal unopposed and lost. He says, that's embarrassing. And I said, well, Bill, let me read it. So I read it, and it was the case of, oh boy, getting old is a pain. Anyway, the court misread the statute. Later, when I lectured on it, I told Superior Court judges at their continuing judicial education seminar, if any of you feel compelled to follow this statute, as you deny the request because of it, file this case, as you deny the adoption, it was a step-parent adoption statute, because of this, hand them my card and tell them I'll take their appeal for nothing. And I did, and I had a judge in Walton County called me, and he said, Jim, there's got a case coming your way. I just gave you the platform you needed. The Court of Appeals, I had 2 of the 3 judges on my panel that had been on the panel that I was trying to get them to realize they messed up on. In fact, Judge Beasley wrote the opinion, and I went and contacted her before all this happened and said, how did you get to this point? You say that the General Assembly has to correct the statute, but and I wrote it, and I'll be glad to go correct something I got a mistake, but I've studied it, can't find the mistake. And we talked about 40 minutes, and she ended the meeting when I said, well, what can I get the General Assembly to put in the statute that will cause you all to read it? And we'd been over it umpteen times of why the black and white definition was this, and they didn't read that definition, because she said, it had to do with the definition of parent. A biological father who has not legitimated a child is not a parent in the definitions. And they had said that we didn't provide for that. And I said, well, you see that a mere biological child isn't a parent. And you cited, ironically, in that same opinion, 2 other definitions from that definition section, so I knew they knew the definition section existed. And we went through all this painstakingly, and that's when I got to the end and said, well, anyway, she wasn't on the panel. She'd been elevated to the Supreme Court by then, so she wasn't on the panel. And I wrote in the footnote, I realize I'm asking 2 of you to correct this, and you were there before. What a perfect opportunity for you. And they denied my appeal. So I filed a application for cert, thinking, well, the chances of this are slim and none. They granted it. And during oral argument, one of the justices said, what do you think the Court of Appeals will think of this? And I said, well, I gave them a chance, Mr. Justice. I hope they like it. I hope they read it. So the Supreme Court was aware of the history. But anyway, it's been corrected. But it had to do with terminology. And we can soften words and whatever, but we have to read the code. There's no evidence that adoption court pleadings or agency files were sealed to protect the identity of the birth mother. That's an urban legend. There's nothing in the law that promised birth mother anonymity or confidentiality, because the records were always openable by court order without any standard. So it didn't say upon consent of the mother. Denying adult persons access to identifying information related to their birth and adoption has potentially serious negative consequences with regard to their physical and mental health. I found this this is a quote out of one of the studies here. And the next one is the Family History Initiative of the U.S. Surgeon General's Office concludes that part of what I was talking about, the failure to have vital diagnosis information and everything else, can cause. So this one's going to be cited the next time the judge wants to say, did you make that standard the U.S. Surgeon General says, yeah, it can cause you to be adversely impacted. The opponents said that abortion rates would increase if we opened records. The data says otherwise. The states that have open records have lower abortion rates than Georgia. And 2 of the states, Alaska and Kansas, never closed their files. And the reopening, the states that have reopened them, show no increase state to state or time period to time period within that state of any change in the. So that also was one of the, and that of course was dropping one of those loaded words into the General Assembly, holler abortion, and everybody, I got my phone ringing, you know. And birth mothers have taken out newspaper ads to support opening records. They've signed petitions. The American Adoption Congress has over 1,200 birth mother signatures on a petition to grant OBCs to the children that were placed for adoption. So it's, here are states, Alabama, Delaware, Illinois, Oregon, New Hampshire, Maine, Rhode Island, and Tennessee. Interestingly, 2 of them that border us have opened their records. Tennessee has a no contact preference to where a birth parent can file with the state a statement that says, I don't want to be contacted by the child that I place for adoption. And that's given to the adult adoptee when they get their OBC. So you're on notice that the mother's name on here doesn't want to be contacted. Again, most of the adult adoptees aren't interested in contacting somebody. They're looking to see the first piece of paper that documented their existence. And I've gotten as close, I think, as one can to someone who was adopted and I'm not. In the many cases I've handled, in hearing the emotional, it's like one of those puzzles that there's a piece missing right here. This puzzle is my family history. I can complete it. And you could say, oh, I can still see the picture, it looks fine. But to the person who's trying to complete that picture, that's, you know, it probably grew in size. It's now blocking their vision of the picture. So it's a very compelling issue. The rap star Daryl McDaniels, Run DMC, he found out he was adopted at 30, somewhere in his 30s, and he wrote a song. The lies and secrets around adoption build guilt and shame. They, OBC, access, is really about identity and truth of a human being's existence. We never start a book from chapter 2. As adoptees, we live our lives from chapter 2. And I think that symbolism is so powerful that if any of us pick up a novel to read, and I tell you, nope, you got to start on chapter 2, that book will never be as meaningful as if you could have started in 1. And I'm not saying that as an author, I'm saying that as just think about it. Other reasons that you need an OBC. After 9/11, you may not be able to get a passport because the passport agency will see this as an amended document. They see things we don't see. And they'll say, I need to see behind this. I had a client who wanted, from Alabama, who was a doctor in Alabama at the time. He was adopted in Georgia. His daughters were eligible for the Daughters of the American Confederacy, and the same would apply for the Daughters of the American Revolution. But he had to provide his birth certificate because he'd had reunion with his birth mother, and she was in the Daughters of the American, or the Confederacy, wanted her grandchildren to be members, but we had to provide the link. Tribal membership in Native American tribes, you have to, some of them require tracing your ancestry back to the Dawes Roll, which was an inventory of Indians in 1805. If you can't find a member, you can't trace your lineage to somebody on that list, you might have wanted to think you were part of that tribe to participate in the casino revenues, but you're not getting in, you know. So there are all sorts of reasons. The dual citizenship. One client friend, if they can prove her Irish ancestry, she can get an Irish birth certificate. I mean, an Irish passport in addition to a U.S. You doesn't have to give it up. Australia, other countries. So it's not just a curiosity. It can actually stand in your way. Let's look at sealed adoption court pleadings. I said that they were covered under the adoption statute. It's 19823A, which in part reads, all of the records of the court granting the adoption of the department and any child placing agency that relate in any manner to the adoption shall be sealed, kept sealed and locked. And for those of you who work within DHR, DHS, or in child advocacy and whatever, and a child is the subject of an adoption proceeding, and someone produces for you an adoption pleading and didn't get a court order, they probably have violated not only 19823A, but the Superior Court Rule 39-6 that says those are only accessible. And we're involved in one case where the attorney on the other side has produced a copy of one of those documents in a pleading, and our sanction motion is in draft now because they are admitting that they got a document in violation of the statute and the rules of the court. So we're hoping that the judge will frown on them a little bit because we want the judge to rule in our favor. This goes on in that section and says the records may be examined at the parties of interest and by the agency with 30 days prior notice, written notice and a hearing in chambers, and the standard is good cause. So agency records can be accessible outside the reunion registry under 19823A, but the reunion registry is in subsection F of that same section, and I tend to look at it and try to be sure that before I come into a court asking for judicial action, I've exhausted my administrative remedies, because I think there's no mandate, but it's a clearer to get to the issue. Okay, now we talked about closed adoptions. This is the term open adoption. And it's a relative term, pun intended, refers to adoption in which the birth parent or parents and the adoptive parent or parents are known to each other and have some contact, either initial or ongoing. And it could be that I know that the birth mother's name is Sally and she knows I'm Jim. That would be an open adoption. I had a birth mother call me one time on a referral from another attorney, and she said, Mr. Outman, I want to go to court, and the agency promised me an open adoption, but it's not open. I said, well, describe for me. Well, I know the birth parents' names. I said, time out. It's not open enough for you, right? Yes, that's it. Well, it's still an open adoption. If they promise you an open adoption, maybe it's a little fuzzy agreement. The ship Peerless, is that still a case you all study? But it's not a question of they lied to you on making it open. Primary benefit of openness is access by the adopted person as children or continuing later in life to birth relatives as whether their own medical, genealogical, and family histories. So the primary purpose comes from the adoptees side, and this I thought was a beautiful quote. It's out of one of the studies, that openness exists along a continuum with confidential adoptions, the one that my wife and I had, no identifying information shared, there's no contact at one end, mediated adoptions in the middle, and as an attorney, my law firm that I was with, we would tell the birth mother, if you want pictures, the adoptive parents will send them to us and we'll send them to you. And if you have something you need to communicate to the birth parent needs to communicate to the adoptive parents, you send it to me and I'll send it to them. And that's how both of them wanted it. When I started out in adoption practice, I used to carry two files I maintained two files. One was on the birth mother and one was on the adoptive parent. So when I met with the birth mother, I didn't have the other one with me, and vice versa. Because they both didn't want to know who the other one was. And I didn't want me to knock papers off the desk or get up and go to the restroom and have them go through my file. So that was just a practice style issue I did, but I kept that wall up there. I knew who both, I mean, when I filed them, I really did put them in one file because I had one client. I was either representing the birth mother or I was representing the adoptive parents. I didn't represent both. That, I think, would be unethical. But I maintained that confidence. Now, if the birth mother tells me, well, I only want to be known as Sally, well, I know her full name because I've had to draft the documents to get her surrenders and whatever, but the agreement between the parties is they'll only know Sally and Jim. So and then on the other end of this spectrum, continuum, is an openness. And it can be so open that the adoptive mother was the Lamaze coach, birth coach for the birth mother. I've had adoptive parents be in the delivery room for the delivery of their child. And, you know, a totally supportive, embracing, open relationship. So when we speak of openness, it's always shades of gray. Levels of openness. This was a study done through the Evan B. Donaldson Institute between 2008 and 2010 that 5% of the adoptions they contacted were confidential, 40 were mediated, 9% were disclosed but no ongoing contact. So that may be, I'll send you some pictures initially, or we at least saw each other at the hospital and then we parted. And fully disclosed with ongoing contact, 46%. This is a sign of today. In the last 10 years, 12 years or so that I've been in private practice, I've not done a closed adoption. The people who have come to me usually already ready to adopt. They know each other. Or if I was involved in helping a birth mother find a family by presenting some families to that once she picked them, they were in relationships. So it's a proportion of agencies offering open adoptions, and this again is from studies. In '87, it was only 36%. '99, it had jumped to 79. In 2012, it was 95%. So the agencies have come, I'll say almost full circle, not half circle, excuse me. Don't want to do a 360, you'll be back where you were. You want to do a 180. So the whole world of adoption, it understands the importance of the exchange of information, which makes the irony all the harder when you get to a judge today saying, I want to access a record that was sealed back then, but we know now is so, well, no, I don't think you ought to have that. So, impacts of openness. Provide access to the birth relatives and thus to their own histories, so that if my son's seeking to find the identity of his birth mother, it's for his benefit to know his history. Understanding the reasons for adoption. A lot of adoptees glorify their birth mother. She was an angel. She in the early books on adoption, Roy Rogers and Dale Evans, they adopted children. Well, I think they did, but they also had a Down syndrome child. That's what I was remembering, the book that she wrote. The key is that they tend to, what a wonderful thing you did for me, James's birth mother. But she was at a place in her life, it was a pretty good thing that she was able to do for herself, possibly. She made the decision, and it may have been, sometimes it's very selfish. We have families that don't want the children, but they also don't believe in abortion, so they were left with a child they didn't want, that they needed to turn to adoption, so it solved their problem. That's not all bad to share that with an adult as to how they came into being. Let them know the facts. And there's all sorts of write-ups and stuff about if the child was a product of a rape, do you tell them, and everything else. But those issues, yes. The truth never hurt people as much as secrecy does. And one of the Donaldson Institute's mantras about open adoption is, what do we keep secret? Do you all keep good things secret? Or do you keep things that are shameful, bad, you're embarrassed? That's the general association with the word secret. So if I tell my son his adoption's secret, he might think, well, maybe I wasn't supposed to be adopted. And again, we adopted him in '73. I would be with him, introduce myself to somebody. Mary Margaret, here's my son we adopted. Does he know he's adopted? Yeah, he knows he's adopted. Best thing that's happened to all of us, you know. But they were, right here in River City, they were saying to me, does he know he's adopted? Because that was what we whispered about. And we're not there, but we still are there. Identify where traits come from. Hey, Mom, I can play a musical instrument. You give me one, I can play any of them. I can't carry a tune in a wet paper, you know, in a box. Well, I didn't get it from me, you know. Positive feelings toward birth parents. They may be resentful at the birth parent. Why'd you give me up? And rejection. There's loss in the adoption triad, shared by all three members of the triad, the adoptive parents, birth parents, and the adoptee. Every one of them has lost something. You think about it. And they share that loss and grief, but they can't do it openly, and they tend to blame others or whatever. Well, if they can talk to each other, it's going to be healthier. Additional support for the adult relationship. Impact on adoptive parents. In fully disclosed adoptions, they feel a greater sense of entitlement to parent and less fear of losing their children to birth parents. As an adoptive practitioner, when we would have the news cases of the baby David case out of Ohio and the baby M case out of Wisconsin and Michigan, when those things would hit the news, both of those cases involved 2-year-olds being turned back over to their taken from their adoptive parents' families with the news cameras here and given to the stranger, the birth parent that had not parented them, but been lied to, whatever. My phone would ring. That ain't gonna happen to me, is it? Can't happen here, can it? I mean, it's an anxiety. And until you can get to that final hearing, that anxiety level's way up here. At the final hearing, it drops. We've got a statute of repose now. 6 months later, it should go off the table. Because now, if you don't attack an adoption judicially within 6 months of the date of grant, you won't, can't. And it's been upheld by an appellate court, thank goodness, in this last year. But that anxiety level is very real. The fear of an adoptive parent that the birth parent is going to come back. Well, if they're in a relationship with each other, I don't have to have that fear. I just saw her last week. We had lunch together. So, greater empathy and more positive attitude towards the children's birth parents. If I understand their situation, I don't have to make it up. I can say, boy, that was terrible, but I'm glad I can be part of a solution to your problem and you're the solution to my problem. Aren't we both good for each other? Unwanted intrusions. This is one of the ones that I talk about in the openness continuum is that boundary line maintenance. The woman that called me and said that she knew the names, but it wasn't open enough. Well, she wanted very frequent contact. You know, can I come over and have dinner Sunday night? No. You know, I got to parent my child. And too much of that can cause confusion. Certainly, when we've done agreements, it's you shall not refer to yourself as mother or father type of language. Positive experiences is openness to greater satisfaction with the adoption process. Again, if you understand everything that's going on, you have less fear of that unknown, and you're more satisfied with the results you have. Birth parents can report less grief, regret, worry, more relief and peace of mind. The reunion registry searches, when we've effected a search, if you had Peggy Rothschild speak to you, who is the project manager for that reunion registry, they'll tell you the number of times, oh, thank God you called me. I was afraid I was going to die without knowing what happened to my child. It was such relief to know that the child Johnny was alive and he was well.
Jim, does the state still use a private investigator? That was the original mechanism.
They employ an investigator as part of the reunion registry to help with the search, because figure the search, if James, my son's looking for his birth mother, they got a record, 1973, she was 16 and living at this address in DeKalb County. Well, odds are on she's not at that address anymore. So they need somebody that can take that information and find her today living in Augusta and married and what her new name is. And there are people that do that. Now, some of them are spoken of as adoption angels. You go on the internet and say you want to find your birth parent, or a birth parent wants to find a child. There are all sorts of internet search boards that you can put. I was born on March 13th, 1976, and in DeKalb County, Georgia, and placed for adoption. I'd like to find my birth parent. Please contact me. And so Soundex is one of the longest running organizations that does that. Well, those services are out there. Well, they're using private investigative techniques and the woman that does the work for Reunion Registry has done it for years, and she'll come back and say, well, we found him in the high school annual, and I found this, and I found that, and we're pretty sure that's who the person is. And then they can start phoning people or sending letters and stuff. Birth mothers more positive about the outcomes than those without direct contact, more satisfied with their birth mother role, and report greater satisfaction with the adoption process and better post-adoption adjustment. So they get on with their life better. Wouldn't we want that for every one of them? Everybody involved, we want them to have a better shake at it, and this helps. The next discussion will be on taking this openness a little bit more, talking about post-adoption contact agreements, what they are, what they could look like, what they couldn't look like, why they're viewed, how they're viewed, and then we want to involve more of a discussion, because part of our thought here is we have an excellent opportunity to have a good give and take with people who are concerned about this area. So we'll now take a 15-minute break. So I've got 5 after 3, so at 20 after 3 we'll reconvene. Thank you. During the break, I had one comment discussion that prompted me to remember something I didn't share with you. I was talking about the adoption files being sealed, and I said that the court files and the agency files, including the Department of Human Services. But that statute does not read to the practitioner who represents the adoptive parents. So I can have in my file a copy of the adoption decree and whatever, and I could be contacted by the birth parent and say they've lost theirs. Do I have to go to court to get it? And I say, no, I can give you a copy. And I'm not violating anything. But I've had occasion to be in court proceedings where the case manager on the other side, involving a juvenile court matter, had in their possession documents from adoption files. And I'd invite them to read 19823A because it reads that it's sealed, the department's records are sealed. And that doesn't mean they can go use them anywhere within the department. That means the department record is sealed. And the fact that there is an exception in 23A or 23 that says the agency may reuse its records in a subsequent placement of the same child. The child comes back into care after an adoption, you can reuse that file. But the fact that there was a juvenile court matter involving the same parent and there was an adoption proceeding, that didn't make that adoption file fair game in the juvenile court. So I've seen it. I know I'm a realist. I know things like that exist, but part of my mission here was to educate that if you're a case manager, it says you can only share that file with an order of the court. Thank you.